I appear for the Department of Communities, who are the department in Northern Ireland responsible for the impugned provision. This is a parity measure, so it's the same in content and effect across the United Kingdom. So the import of this case has ramifications far beyond this jurisdiction. Lords, ladies, we say that there are many benefits to being married. The law of the United Kingdom adds to those benefits by conferring certain fiscal, financial and social security advantages upon those who are married. The benefit at issue in this case is one of those advantages conferred by the law. We say, as a general proposition, the conferral of additional benefits or advantages to those who are married does not offend the Convention. We say that the European Court has endorsed that proposition on a number of occasions. One reference would suffice, ladies and lords, the case of Yigit, which has already been opened to you. You don't need to open it, but it's at tab 9 of volume 1 of the authorities, MS 1228, paragraph 72, describes how the protection of marriage constitutes in principle an important legitimate reason which may justify a difference in treatment between married and unmarried couples. Marriage is differentiated by a corpus of rights and obligations that differentiate it markedly from the situation of a man and woman who cohabit. Thus, states have a certain margin of appreciation to treat married and unmarried couples, particularly in matters falling in the realm of social and fiscal policy, such as taxation, pensions and social security, differently. Since 1925, this state has made provision for the payment of a benefit to those who have lost their spouse through bereavement. One of the earliest statutes of the welfare state is the Widows, Orphans and Old Age Pensions Act 1925. My lady asked earlier if there was anything in the papers that gave a background history to that. I could refer you to, without opening it, MS 734, which is a government paper dealing with the background to that benefit and also tracing its genealogy through to the modern day.
It was my impression that it went back a long way.
Yes.
And of course went back to the days when married women didn't work.
Yes.
So to become a widow was the same sort of loss of income as losing your job or becoming incapacitated.
Yes.
Or indeed reaching a certain age.
I think
it was lumped in with those sorts of incapacity in those days.
Interestingly, it continued through the beverage reforms. It was reenacted in the 1948 National Insurance Act and has been reincarnated in various forms thereafter and remains to this day in the form of the widowed parents' allowance and has some continuing trace in the bereavement support payments, which is the present benefit. What we say about that is it's interesting, and the court, we can actually provide the court with a House of Commons research paper from 1998 on widows' benefits, which is a better public-facing document dealing with the history of this legislation. It's unfortunately not in the evidence, but it's, I hope, not a contentious paper. It will assist the court in understanding the background and the philosophy behind this particular benefit. What we say is striking is that in the 93 years since we've had a benefit of this type in this jurisdiction, there has been one constant bright line rule in respect of eligibility, and that is that the benefit is available only to persons who meet the eligibility criteria and who are the spouse or civil partner now of the deceased. The maintenance of this rule throughout that 93-year period is no anachronism or oversight. The retention of this criteria has been a positive policy stance adopted by successive governments and endorsed by successive parliaments. The benefit which we're focusing on today, widowed parents' allowances, will no longer be available from April 2017 and has been replaced by a new benefit called bereavement support payment, introduced in 2015 in Northern Ireland after this litigation commenced. And one of the interesting features about that benefit is that it also retains the same eligibility criteria and is not available to those who cohabit. So
Am I right in thinking it's a much shorter term benefit?
It is importantly different. It's available only for, I think, 19 months at a maximum, whereas this benefit, as my Lord Hodge identified earlier, can be payable for up to and perhaps slightly over 20 years. So it's an altogether less generous arrangement, and indeed questions of cohabitation may well pose fewer problems on a 19-month time frame than on a longer time frame like this. But BS...
The 2017 benefit, does it replace the allowance that we're dealing with here?
Those who are eligible for this payment and who are already eligible will continue to receive it.
I see.
But someone who loses a spouse today
Yes,
will be arguing for their entitlement to bereavement support payment, which is, on many respects, a less generous provision.
What's it called again?
Bereavement support payment. It was introduced in
Bereavement
support payment.
Support payment, thank you.
Yes, please.
Yeah.
Introduced in the Pensions Act 2014 in England and Wales, and in the Pensions Act Northern Ireland 2015. I'll take you briefly to some parliamentary materials in respect of that. So, as I've said, we have here a bright line rule which has been retained repeatedly following parliamentary consideration. And that parliamentary consideration has from time to time involved engaging with exactly the issue that's raised in this appeal. It has been argued that this criteria should be changed so that those who cohabit have an entitlement to this benefit. Can I assist the court with some references to the parliamentary materials in respect of this?
Well, not for the purpose of interpretation.
No, just for, in terms of legitimate aim and the purpose of that, my lord, my lady.
The research report to which you refer, is that 19/100 of
Yes.
1998?
Yes, it is. The question of extending this benefit to cohabiting couples was debated during the House of Commons committee debates on the Welfare Reform and Pensions Bill 1998-1999. The question at issue at that time was the extension of this type of benefit to widowers as well as widows. And in the context of that debate, again, the issue was being raised of extending the benefit to other categories, including cohabitees. There's an important speech by the Secretary of State, Under Secretary of State, Mr. Bayling. He was Under Secretary of Social Security, which was appears in the papers at Volume 2, MS 833, but there's a much more legible version at MS 909. 909. Volume 2. The full debate is at 833.
Is this the core volume?
Yes, core volume 2.
It's here. You've got it here. On top of my papers.
So, briefly looking at, actually one begins at 908, you'll see bereavement benefits in unmarried couples, and there's a discussion here of how the legislation developed. At the bottom of the page, discussion of the committee stage debate on the Reform and Pensions Bill 88-89. And
So
then
what's this document that you're...
this is another government paper, bereavement benefits House of Commons note. It begins maybe at 901, so it's a briefing paper on the background materials.
Thank you.
But I'm drawing your attention to the debate, or the speech, which begins at 909. And the contention was that these benefits should be expanded to make provision for cohabiting couples. And you'll see that, picking it up at the top of that page, we intend to continue to base entitlement to bereavement benefits only on legal marriage between couples at the time of death. I believe that's right for two primary reasons. First, marriage is a cornerstone of the contributory benefit system. Marriage carries with it special responsibilities. The state recognises that fact, and bereavement benefits reflect that recognition. Secondly, marriage provides a straightforward method of deciding whether benefits should be paid. It would be far more difficult to administer and police the benefits if they're extended to unmarried couples. So two aims there. One is to adhere to the principle that marriage is a cornerstone of accessing contributory benefits.
Now, what did he mean by that? He won't only have had bereavement benefits in question,
Yes.
he'll have meant something else as well.
Yes.
Things like possibly married women qualifying for retirement pensions on the basis of their husband's
Yes.
contributions. Well, that's no longer the case, is it?
That's probably no longer the case.
Yeah.
He's drawing a distinction, important distinction here, in respect of contributory benefits, not ordinary means-tested benefits, which
Yeah,
we'll come to in
absolutely.
due course, which
Yes.
are fundamentally different. So we stress, again, the focus on the contributory nature of these benefits, for which historically marriage has always been one of the elements of entitlement, particularly when one is going to receive the benefit of another person's contributions, which is what happens in these cases. The spouse, the surviving spouse, receives the benefit of the contributions made by someone else. The second point he makes is the need for an administratively effective system. Lord Mance was touching on this earlier today. Marriage provides an objectively verifiable, low-cost means of identifying who is in and who is out. So when one's looking at bright line rules, as we are in this case, that is a reliable indicator that can be discharged with economic efficiency by a large-scale social security system. So that one sees there in that presentation the two key legitimate aims of this legislation. Interestingly, also in that same debate, the issue is raised about the impact on equality and on children. And he addresses the issue in the third paragraph about the difficulty of asking intrusive questions upon individuals at the point of bereavement. He raises the issue of potentially conflicting claims by those who assert that they were cohabitees and may not have been. And he identifies a difficulty with administering this type of arrangement. Those statements have been restated in subsequent debates where these issues have been raised. Questions of cost are also not irrelevant. I'll give the court another reference. Volume 2, the same volume, MS 836. There's a ministerial answer to a question about the cost of expanding bereavement benefits to cohabiting couples. The Minister at this time, in 1999, was anticipating that expanding these benefits to include unmarried partners would cost around 100 million per annum, it was said, by 2020 to 2021.
Is that a very good reason?
No, we're not relying on cost as a consideration.
It does appear to have been a reason, and it doesn't seem a particularly fair reason.
Yes, we're not relying upon that, Lord, as a basis for...
Can I just ask, has this issue, I mean, this issue is one which could have come to the fore at any time in the last, I suppose, 15, 20 years, or possibly more. Why has it come to the fore now in particular? We're told that financially, at any rate in this case, it may not make much difference.
Yes.
No doubt you may come to that.
Yes.
Is that true generally? I mean, this case has been supported by Citizens Advice Association, also by Legal Aid, but why not before? Do you know?
Well, I'm not sure I can give a direct answer to that. There have been reforms of this. If one looks at the incremental reforms of the benefit, initially it was expanded away from widows to include widowers. Then in 2004 it was expanded to include civil partners at that juncture. So the benefit, which started off in 1925 with focus on widows, has gradually spread out in a wider form. And that has provoked the argument that it should be extended further to those who are cohabiting. That seems to be the residual category for whom there is no additional benefit. Now,
It would be interesting to think what they would have done in 2004 if it hadn't been extended to widowers
yes,
before then.
yes. The extension to widowers, of course, was compelled in part by litigation before the European Court of Human Rights.
Oh, yes,
as you know.
we realise that. We've
Yes,
seen that.
But why now? Well, I'm not sure I can give an empirical answer to that, my lord, but it is right that for this claimant, the additional financial advantage of obtaining the benefit while she was not in work was modest. That is because this benefit is treated as income for the purpose of other benefits, which are then deducted pound for pound for everything except a £10 disregard. So for those at the lower socioeconomic tiers, they will have their benefits reduced, save for the £10 disregard. For those who are in work, and in fact the majority of people who receive this benefit are in work,
Yes.
not this case, they will receive a benefit on top of their earnings.
Oh, it's worth a lot because it's not taxed.
It is taxed.
It
Yes,
is taxed.
it is taxed.
Yes, but it's.
But it is available for 20 years if one's in that situation. Now,
So it will be taxed on top of those.
Yes.
yes,
It's taxed.
Point on top, yeah.
exactly. But the actual benefit in real terms for someone in Ms. McLaughlin's situation at the point of claim would have been modest.
And for those who...
£10 per week.
Yes.
And for those who receive it on top of their income, there isn't the £10 disregard, is there? I see, so it's just the whole lot, so there's no benefit.
No, they get the lot.
They get the whole
They
benefit.
get the lot.
They get it subject to taxation.
Quite subsidy taxation, yes, yes, I get it. Yes, I see, yes, I'm with you, yes, I get it.
Stepping back, it's probably more advantageous to someone who's in work to receive this benefit than someone who is on the subsistence level relying on benefits.
It's taken into account for the purpose of tax credits, is it?
Yes.
Both child tax credits and what about child
I'll be
benefit?
correct if I'm wrong, but I believe that's the case.
I think it'd be
Yes.
of some interest to know, but
We'll check that detail. So, the issue of extending the benefit, again, perhaps this goes back to my Lord Mance's question, was considered again in 2011. There are materials before the court, page 838, volume 2, public consultation document on bereavement for the 21st century. And again, at that juncture, consideration was being given to reforming the overall bereavement benefit scheme, which was seen as being potentially costly because of the protracted length of the benefit. There is in that document some helpful material for the court in terms of understanding what the benefit was about and how it works. At page 850, you will see at the top of the page a description of the key function of the bereavement benefits. The second paragraph is to provide some financial security in the period immediately after spousal bereavement to allow people to take time away from work should they need this. So not expressed in terms of a benefit for children necessarily, but to allow a person to retain some financial security if they need it in the period immediately after bereavement.
what's this?
This is the government's public consultation document on bereavement benefit for the 21st century. It begins at page 838,
Date?
2011.
And which bit were you reading?
I was just reading from the top of page 850, MSS 50.
Page 16,
Yeah.
top of the document.
Yeah, I've got it, yeah.
And over the page, my ladies and lords, you will see a heading out of scope, issues that are out of scope for review. And there's a heading halfway down the page, marriage and civil partnership is a condition of entitlement. And you will see that currently the law only recognises the inherent rights and needs of bereaved people if they've recognised marriage or civil partnership. This is despite societal change resulting in a decline in marital status. We have no plans to extend eligibility for bereavement benefits to those who are not married or in a civil partnership. And that remains the position whenever the legislation is debated. Final reference from the materials on that will be the parliamentary debate on the 15th of January 2014. You'll find this at MS 917. This is the debate on the pensions bill, bringing in bereavement support payment. And Lord Freud, who is promoting the legislation, at page 936 gives another answer to the question of whether it should be advanced to cohabiting couples. And he restates the position again in the middle of that page. Our law and tax systems recognise inherent rights and needs only if they have a recognised marriage or civil partnership. This stems from the founding principle of the national insurance system. All rights to benefits derived from another person's contributions are based on the concept of legal marriage and civil partnership. Allowing cohabiting couples to have access to bereavement benefits would significantly increase complexity. Proving cohabitation can be incredibly challenging, not to say an intrusion into a claimant's private lives. That's the...
I'm sorry, where is...
I'm sorry, my lady. That's the...
936.
Sorry.
936.
Page 936. Does bereavement support payment depend upon having dependent children?
I think it does. Yeah. I think the eligibility criteria are the same. We will find a page reference in respect of that for you, lady. But the benefit is different, the duration is different, the amounts are different. So, looking at the benefit we're dealing with, widowed parents' allowance, it's a contributory welfare benefit. It is not means tested. It is taxable. It is payable whether the survivor works or doesn't work. It is not a subsistence benefit. We say it is not a benefit payable to or for children. Can I focus on that topic for a moment, my ladies and lords. The appellant's case is, and certainly supported by CPAG, this is a benefit for children. And through that gateway, a great deal of complexity rushes. Article 8, the question of ambit, the engagement of UNCRC and other international instruments flows in large measure from that point. Our first answer to this is the straightforward answer, that it is not a benefit for children. Can I develop that with some headline points? Firstly, the terms of the provision itself, section 39A, are clearly expressed. It is described as a benefit for the survivor. It is not described as a benefit for the children. Our second point is that the benefit is payable when a person is pregnant and there are no children. Section 39A, 2, B and C. It's not our best point, Lord, no, but it's still a relevant point. Significant in this sense, my Lord, of course, pregnancy may or may not lead to a successful outcome in terms of a child, but the benefit will be payable for another 20 years if someone meets the criteria. Similarly, the benefit is payable. The benefit's payable in the event that a child is outside the jurisdiction. The child doesn't have to be in the jurisdiction in order to receive the benefit. For the effect of regulation, I'll give you the provision in due course. So there are features of this which move it away from the focus on an individual child. Our next point is that the benefit is payable at the same rate no matter how many children there are. So it is not calibrated by the number of children, unlike, in fact, the predecessor widowed mother's benefit. It's not payable to children in the tragic event that both parents die together. In those circumstances, this benefit does not apply. Instead, the provision is made by the state for guardian's allowance.
I was going to say, there is an alternative.
There is an alternative, yes, but not this benefit.
What happens if, to the benefit of the surviving half of the couple dies? Does it cease to be payable then?
I expect the answer to that is yes, because it's payable to the survivor only.
Yes.
And again, if someone's behind...
So it just ends? The children don't get anything?
Yes, yes.
But there is guardian's allowance.
Yes, guardian's allowance applies in the event that a child is orphaned.
And am I right in thinking that guardian's allowance is also a feature of the contributory benefits system? Sorry, I keep on asking these questions because I used to know a lot about social security law, as it may be apparent.
I probably should know the answers to those, but
I have forgotten enough, and things change. That's why I'm asking the questions. I don't want to
we
make
think
my
it's not part of the contributory benefits
You think it's
system.
not part?
Not part, yes.
Oh, that's interesting, yes.
My next point in respect of this topic is that the benefit, when it is payable, is not calibrated in any way to the needs of the child. So there's no assessment of what's actually needed. And I contrast there the situation when subsistence needs are being met through benefits. When subsistence needs are being met through benefits, they are means tested.
But it's long been a feature of the benefit system that you may have something to which you're entitled, which, if it isn't enough, will be topped up by means-tested benefits.
Yes.
I mean, that's been the case with retirement benefit for a long old age pension, as it used to be for a long, long time. And so the same could apply here.
Yes.
And does.
Perhaps the flip side of my point is that on this issue, if this benefit was intended to meet the subsistent needs of children, then there would be no justification for having contributory benefit criteria as an entitlement condition. So if it was really meant to help children meet their basic needs, then it wouldn't be set up this way, because the contributory benefit criteria will disentitle many, many more children than the cohabiting criteria. So where someone simply hasn't paid enough national insurance contributions, the benefit isn't payable. it's not a benefit, we say, to meet the subsistence needs of children. The underlying point behind that is that in the United Kingdom social security system, the obligations which are there to meet the needs of children, where a breadwinner is lost through death, is the means tested benefit system. So the safety net is not widowed parents' allowance. It is the general social security provision that will apply through child benefit, child tax credits, and the other benefits which may well apply in those circumstances.
Am I not right in thinking that there used to be 3 bereavement benefits? The immediate bereavement payment, which was a one-off lump sum, relatively modest. What used to be widowed mother's allowance, which depended upon your having children, and a widow's pension.
Yes.
So that it distinguished between the widow's pension and the widowed mother's allowance.
Yes.
So they must have thought there was something extra that was required or deserved where there were children, dependent children. Now, the widow's pension, as I understand it, has gone, and the widowed parents' allowance is more or less gone, or at least been drastically reduced.
Yes.
But there used to be, when this was all started, there used to be 2. One if you had children, and one whether or not you had children.
And within that, there were different, I think there were different eligibility criteria for the widow's pension. There were also age cut-offs that applied.
I know that perfectly well.
So there were interlocking issues that applied in that context. We say, stepping back from this again, the purpose of the widow's parents' allowance was to allow women, or men latterly, to have the support they need in order to take time off and then get back into the world of work in order to continue earning, not to provide for the basic needs of children.
Yes, I'm not challenging that aspect of what you say. I accept that if basic needs of children are not properly provided for by this, well then means-tested benefits will top up. I was querying your statement that this was not a benefit for children. Because, as I say, there used to be the 2 different sorts, and you only get this if you have children. You used to get something else if you didn't.
We're not denying that there's a link with children, nor are we denying that the benefits could be used by the recipient for the purpose of assisting with the children. That's
the preposition for. You're saying you're accepting it's a benefit because of children, but you're saying it is for the survivor.
yes, and that we say is a fundamental difference. And we may or may not be right about that, but that's our first proposition in respect of this argument. And if we're right about that, then many other points fall away.
Can I just ask you about the benefit being to enable them to get back into work? But actually it would carry on potentially thereafter for a lot of years.
Yes, and that's one of the reasons why there was pressure to change into bereavement support payment, because once a person was back in the world of work, did they need to have the top-up that got them over the initial difficult bereavement period? And that is why the philosophy now, rightly or wrongly, is bereavement support payment is paid for 19 months maximum, then it stops. So it's similar in terms of its value, but not for its duration.
But you can't really say that in its initial stages it was simply to tide you back into work, because that was not the situation initially.
In 1925?
Or indeed in 1948, or probably when I had personal experience of it in 1959.
I'm not going to argue with that, Lydia. That may well be the case. And
Given the nature of society and the number of women who were then working, you can see that it wouldn't have been thought of as being a short-term benefit.
no.
That's right.
My last point on this topic is, I suppose, to look at section 39A3 itself and whether or not it proves the connection with children. And our position on this is we say there is a link with children, but a child who falls within that section may not be either the natural or adopted child of the deceased. It may be that their only link with the deceased is through their mother's relationship with the deceased. So there may be legitimate or illegitimate children in this particular context.
Do you still use those terms in this country?
Well, I don't mean any pejorative sense, Milady, but
Well, it's as well to try to avoid using
Yes.
terms that are regarded as discriminatory and pejorative.
Well, that's not my
Talking
intention.
children of married parents and unmarried parents, because
Yes.
it's the parents who are responsible.
Quite so. So we say that the scenarios in which children may well be connected to the benefit are diffuse in nature, and the clearest nexus between the benefit or for the benefit is between the deceased and the survivor, not the deceased and the child, where the child is present.
But under A and B of subsection 3, would I be right in saying in Northern Irish law, the deceased would, had he lived, continue to have an obligation to aliment the child? So aliment's an old-fashioned word, to support the child.
Yes.
Yes, but in C,
Not so.
necessarily so.
So there's a difference in C. So if the benefit is not for children in that sense, then this is a simpler case for the government to defend. We're at that stage focusing on the relationship between the survivor and the deceased. And this case is all about the cohabitation arrangements. Our answer to that case is set out in full in our written argument, and I don't intend to take the court through the detail of it. But can I just touch on some key points in respect? If we are defending this case on the basis solely of the cohabitation relationship rather than the children, then the legal test is the question of whether the provision in the measure is manifestly without reasonable foundation. It has been suggested this morning by my learned friend, Mr. Donoghue, that there might be a different test of weighty considerations applicable in this context. We say that that issue has been given quietus by the judgment of Lord Toulson in the MA and Carmichael case in the Supreme Court. You'll find it in Volume 5 of the Authorities, tab 46, MS 2722. The head note at 2724 captures the point pithily. At the top of that page, the approach to justification in cases involving discrimination, state benefits on grounds of sex, whereby the court would respect the legislature's policy choice and general measures of economic or social strategy, unless it was manifestly without reasonable foundation. The reasoning in respect of that can be found internally in Lord Toulson's judgment from paragraph 28 onwards. You'll see at 29 he rehearses in full the passages from Humphreys and the Revenue Commissioners and Lady Hale's discussion of that issue there. And it is then followed by a discussion about different positions that have been adopted by the court in various cases which followed. But the issue is, we say, definitively dealt with at paragraph 38 of the judgment, where Lord Toulson, and this is a 7-justice court, where 4 other judges agree with him, affirms that what was said in the Humphreys passage, said it above. It follows that in this case the courts have applied the correct test. So we say the test is beyond dispute. The question of whether or not the measure is manifestly without reasonable foundation, not some other test. In assessing the question of whether or not the measure is justified, we say the question of analogy does have to be considered. We recognise the position that's been taken in by Lady Hale in AL in Serbia, but we say in this case, where the statuses are obviously different as between a cohabiting person and a married person, it is important to address the question of whether the circumstances are analogous. The appellants are very keen to leap over that stage and move directly into justification, unsurprisingly, because it allows them to evade the shackle of shackle, the burden of burden, and the Yeaget case, all of which are, we say, fatal to their position. The European Court has repeatedly restated the same principle. Now, the circumstances and facts of those cases are all different. You've been shown the relevant passages today, but the underlying principle is the same. And the Grand Chamber has, on at least 2 occasions, endorsed the shackle analysis that for those purposes, cohabiting couples and married couples are not analogous. And if they're not analogous, that is, we say, another terminal event in the debate. We also observe that in this area, we are dealing with the type of socio-economic provision about which the European Court has recognised there is a wide margin of discretion to be afforded to the legislature. We also observe that what we're dealing with here in respect of cohabitees is a non-suspect ground, if I use that language, of discrimination. It's a ground based on marital status rather than something inherent or innate or not amenable to change by choice of the individual. And we say that all again is important material for consideration of the justification in this case. I've outlined what the legitimate aims are in this case, as I've drawn in the parliamentary materials. It is important, we say, that those who are at the lower end of socio-economic spectrum, who may well call upon these benefits, will receive a modest bonus from it. Their main provision, if they require subsistence from the state, will be by virtue of other benefits. It is also the case, we say, that the availability of benefits of this type should make marriage more attractive to some people who are in long-term relationships. And that is, again, in accord with the legitimate aim identified in the passage of these pieces of legislation. Can I turn to the more difficult case against us, which is the case developed today by Mr. Donoghue and in writing by the Child Poverty Action Group. The battleground in that case is not on Article 1 of the First Protocol and its application with Article 14. It is with respect to Article 8 and its application. This is an area of jurisprudential discussion that has evolved since the Court of Appeal gave its judgment in this case in 2016. A number of the authorities that have been cited to the Court today were not in existence at that juncture, and indeed the law in this area continues to evolve. Only last week we had the judgment of Mr. Justice Ousley in the Universal Credit case, SC, which touched on exactly these issues in terms of Article 8 and ambit. And it's on this topic that I hope to assist the Court. We say that the submission that the provision of this benefit is within the ambit of Article 8 is contentious. The ramifications of holding that a welfare benefit of this type falls within the ambit of Article 8 are potentially significant. The import of engaging Article 8 in this way is that the justification analysis is different. It is said it will import the UNCRC Article 3.1 obligation to ensure that the best interests of the child are a primary consideration in developing the measure in question. Our case here is that this benefit falls to be considered as being within the ambit of Article 1 of the First Protocol. The first point we make about it is that we say the Court should regard A1, P1 as the lex specialis in this context and should go no further than A1, P1 unless there is a compelling reason to do so. And I'm reminded here of my Lord Kerr's observations in the Muhan case, Volume 2 of the Authorities, tab 17, MS 1658, agreeing with Lord Hodge in the same judgment, where two provisions, he says, are capable of governing the same situation, a law dealing with a specific subject matter overrides a law which governs only general matters. In our submission, A1, P1, dealing with the property interests of the survivor, is the lex specialis covering this territory. The more general and elastic consideration of Article 8, we say, is not applicable. that approach of reliance on A1P1 in these cases is reflected in what this court has done in other similar circumstances. In Humphreys, for example, Lady Hale dealt with the argument there through the prism of A1P1 rather than Article 8. The same approach was taken by the court in the SG case in respect of the benefit cap. There are very few Strasbourg authorities which deal with issues of this type through the context and through the lens of Article 8. Almost all of the relevant case law deals with Article 1 of the first protocol. But there are a number of cases which do take this line, and I should deal with them. The first is Aldegar Tomas, Spanish case, 2017. You'll find it in Volume 2 of the Authorities, tab 20. MS 1785. And this is a case about survivor benefit for a same-sex cohabiting couple in the Spanish scheme. And the argument was, again, that this was discriminatory, breach of Article 14. The conventional argument is usually this is dealt with through A1P1. The court in this case elected to address it through Article 8, and you'll see that discussion from page 1805, paragraph 72 through to 75, 76 rather. I'm not going to take the court through all of the reasoning. My submission here is this judgment, which is relied upon by the appellant and by CPAG, contains virtually no reasoning as to why it is within the ambit of Article 8 rather than the ambit of A1P1. And indeed, there's quite a strong dissent from Judge Keller, which you will find at the beginning of the judgment, 1789, and paragraph 14 of his dissent. Her. Sorry, her. There is a discussion of the nature of the de facto relationship falling within the ambit of Article 8. That is not the issue in the present case. The question here concerns the right to retroactive equal treatment in purely financial matters of same-sex de facto couples who could not marry because of their sexual orientation. So there's limited reasoning as to why we are dealing with Article 8 in this context. I accept it's an authority against us, but it does not, we say, purport to state a general principle beyond the...
Were there any children involved?
No children involved. Second case relied upon against us by CPAG is JM, which was M in the House of Lords in 2006, went to Strasbourg. You'll find the authority at 7B. That's tab 82, page 3662. And there was, in the House of Lords...
What was the page reference?
Sorry, 3662 MS.
That the documents in the supplementary bundle aren't accessible electronically.
Oh.
It's like this.
Oh, thank you very much.
These are bundles, I think, which came in a little later.
Yes, but they still ought to be supplied electronically.
Sorry, matey. I will be referring to a number of cases in these bundles, so it might be useful to have them to hand. The intervener filed them. I hope they were filed electronically, or I don't know the answer to that.
These are CPAG's authorities?
Yes, there are two bundles of those.
Yes, I'm told they were. I'm told that they were filed electronically.
Was that by way of email?
I didn't know there was any issue about this. So I just take instruction. My Lord, I'm told that it was through the OES printing service, so if there's something's gone astray, we'll have to make inquiries. favouritism or?
Yes, it usually comes as a separate file, but there's only one.
It's only one file at the top of my
Yeah.
I've got two.
computer.
Oh. Oh.
I got it from G drive.
Well, we've got hard copies anyway.
I'm told by my junior that my solicitors checked the court on Friday and were told that you did have them electronically, my lady.
Yes, in fact, on our shared drive, we do have a supplementary bundle. It just hasn't been downloaded probably for today.
Yes.
I have my hard copies if anyone hasn't got them once.
Well, it can
Well,
be
we
done.
need, anyway, never mind.
My ladies, my lords, I was highlighting JM, the United Kingdom, which was a case where Article 8 had been debated quite extensively in the House of Lords and is dealt with in the judgment. It's relied upon against us by CPAG at the Strasbourg level. But what we say about this is, if one turns to paragraph 50 of the judgment, that's page 3682, you will see a discussion of the Article 8 argument and the court's conclusion at the bottom of the page, having regard to its conclusion that the case falls within the ambit of A1P1, they decide it's unnecessary to proceed to consider whether it falls within the ambit of Article 8. So,
That doesn't particularly help you, does it?
no, it's not against me. I think that's the point. Isn't it?
Well, no, but, I mean, Humphreys is the same thing. The
Yeah.
the case succeeded on Article A1P1, so you don't really need to go to Article 8. And actually in SG they did discuss Article 8, I think, having looked at it briefly.
Lord Reid discusses it and Lord Hughes discuss it
Yes.
both. And both are, and I'll perhaps come to that in a moment.
Both were dismissed.
Yes, exactly. I'll show you the passage in a second.
Yeah.
The other Strasbourg authority that's relied upon against us is a case called UKSC in Germany. It's a 2006 decision. You'll see that at MS 3750, tab 84. And this is a case where there was a child involved in respect of child benefit, and it was a child benefit which they, as persons who had entered Germany and not had full residence status, were no longer to be entitled. So it was a discontinuance of a child benefit for children in that context. And the court finds that this falls in the ambit of Article 8 and Article 14 taken together. Now, this case has been relied on. I expect the court will hear this again in the cases to come in the coming weeks in respect of Article 8 ambit. It's been relied upon in other similar types of litigation. Our observation about it is, rather like Mr. O'Donoghue, it's a very short judgment. There's no real analysis of why this is within the ambit of Article 8. And interestingly, it's not recited again by the Strasbourg Court in any authority that is prominent in this field. It doesn't feature in the Supreme Court consideration in the case of Carmichael or the other authorities that have considered this issue. But it's worth noting what the issue was in that case, and I'll come back to this when I look at the domestic authorities. This was a case about the removal of a benefit that had been provided for the benefit of a child. So it was the discontinuance of something that had already been provided, and you will see we say that's an important thematic consideration in assessing whether or not these matters fall within the ambit of Article 8. So UKPIS hasn't been developed by the Grand Chamber. It hasn't featured in, for example, the Aldegar case, which was decided in 2017, and we say it's not a significant statement of legal principle by the Strasbourg Court. It doesn't appear in Burden or in Yiget or other cases of that nature. Can I turn to domestic authority on the point? My Lord Mance has raised SG with me. The relevant reference is in Authorities Volume 2, tab 19, that's MS 1707.
One zeros.
1707, my Lord.
Thank you.
And the issue is discussed by Lord Reid, paragraphs 78 to 79, in the context of a discussion about Article 3.1 of the UNCRC and whether or not it applied. The argument being it applied, the best interests of children had to be a primary consideration, and therefore the provisions in question were flawed. At 79, Lord Reid saying, in the first place, there is a question of whether general legislation which limits welfare benefits, resulting in some cases in a reduction in household income, constitutes by reason of the impact of that reduction in income on the lives and circumstances of those affected, and interferes with their right to respect for their private and family life. If it does, the ambit of Article 8 is enlarged beyond current understanding, so as to embrace legislation imposing increases in taxation or reductions in social security benefits.
I'm sorry, could you give both the paragraph number and the page reference?
MS 1732,
Yes.
paragraph 79.
Yeah. Okay.
He then addresses the point that I've foreshadowed. If we do move into a territory where Article 8, we are within the ambit of Article 8 in respect to legislation touching on social security benefits or taxation, then the justification arguments are different. And he notes that at the second half of that paragraph. The argument justification on that ground is impossible unless the best interests of children affected by the measure in question have been treated as a primary consideration, not only in the sense they've been taken into account, but, as Council emphasised, in the sense that legislation is in reality in the best interest of the children affected by it, has major implications for the effect of the Convention in relation to legislation in the field of taxation and social security. So, although Article 8 was in the UNCRC context, we have a strong statement of position from Lord Reid. It is picked up, a similar theme is picked up by Lord Hughes at paragraph 139. You'll find that at MS 1749. And his position is adopting the reasoning of the Court of Appeal. The Article 8 rights of the children are not arguably infringed by the benefit cap scheme. Elastic as that article has undoubtedly proved, it does not extend to requiring the state to provide benefits, still less benefits calculated simply according to need, nor does it require the state to provide a home. Now, Lord Carnwath said nothing about, said that Article 8 added nothing to the debate, and I think when Lady Hale and Lord Kerr didn't engage on the Article 8 discussion in that case.
Well, no, because we thought that the interests of the children were a primary consideration, whether it was A1, P1 or
either way, yes.
8. Which view I think that Lord Carnwath probably took.
Yes, that's right.
So you have a majority there.
One can parse it in different ways.
For the view
yes.
that the interests of the children are primary consideration in A1, P1 cases as well as in Article 8 cases.
Well, yes. And it gets more difficult from my perspective because one has up to a point, the decision in Carmichael, which you will find in Volume 5, tab 46, MS 2722. Carmichael's a case about the changes to housing benefit. Court will recall this. I've already referred to it in respect of the STEC test, which I rely upon, but it also engaged with the Article 8 argument. Lord Toulson gave the judgment, the leading judgment with which 4 other justices agreed.
So which tab is it?
This is tab 46.
Is that good? Thank you. Yep.
Volume 5. MS 2722. And the finding of relevance is in paragraph 49 of Lord Toulson's judgment, where, without preamble or extensive discussion, he states that he would dismiss the Secretary of State's appeal in the Rutherford case. I would allow Mrs Carmichael's appeal and would hold that in her case there has been a violation of Article 14 taken with Article 8. In these circumstances, A1, P1 adds nothing, and does not require further consideration. It's almost the inversion of the way the Strasbourg Court has been presenting this in other cases. So what we have in Carmichael is, it seems, a finding of within the ambit of Article 8 in respect of one of the cases in that appeal, Ms Carmichael's.
Well, what about the other cases where the Secretary of State's appeal was dismissed because the claimant had already won?
Yes.
Carmichael had lost.
Yes.
And so these are disabled people or people looking after disabled people who need an extra bedroom.
And the facts of the individual cases are set out in the appendix, page 2748. And I'm not going to take the court through all of them, but they're important in the next stage of the analysis we have to go to. The analysis we have to get to is, why is it that these cases fall within the ambit of Article 8? Is Carmichael and Lord Toulson's paragraph 49 a statement of general principle meant to be applicable to all social security benefits, or are there defined features that allow for that conclusion to be reached in this case? In other words, how wide does that statement of principle go? And that, we say, is at the heart of the more difficult case that I have to meet. And of course, I only have to meet that if I'm wrong about all the other points and I get into that position. So there is an important task for this court, either in this case or others to follow, to assess what exactly is in play in the finding that we're within the ambit of Article 8 through paragraph 49 of Lord Toulson's.
Should we stand back and ask what Article 8 and A1P1 are doing? I mean, A1P1 is protean. It covers pure financial situations where there's no impact on your private or home life or family life, whereas Article 8 surely does have an added ingredient that it's concerned with situations where your personal life, especially your family life or home life, is affected. And that, so it's maybe in some contexts be very logical to look primarily at Article 8.
Yes. Like Carmichael, for example. Carmichael was a situation where they couldn't share.
But I thought you were trying to suggest that really you didn't get to Article 8 in situations where A1P1 might be said to be applicable, but I don't see that that necessarily corresponds with their respective spheres.
Well, my first submission is that A1P1 occupies the field, no need to go to Article 8. If we're wrong about that, in a case like this, one looks to see what is it about this scenario that engages Article 8. And what I say one can extrapolate from the Strasbourg authorities and Carmichael is that where you have the removal of a benefit that has been provided, and where that benefit directly links to an aspect of your family life, then, in line with my Lord's questioning, that may well be properly within the ambit of Article 8. May well be.
So the benefit is removed, that brings it within the ambit.
Yes.
What if the benefit is denied? Why should that not be within the ambit?
Well, there's never been an entitlement to the benefit in this context, so there's been no expectation of it. There's no reason to think it will happen, and the state has done nothing in order to take any particular benefit away from someone.
But why does that make any difference to whether it affects the operation of your private and family life? Both withdrawal and denial affect the operation of your private and family life.
Well, we say there may well be a difference in terms of the expectations that arise in that scenario. People cannot be expecting a benefit which the state doesn't provide. But if you've been reliant upon it, as Mrs Carmichael was, and find suddenly that she can no longer reside in the same way with her husband in her own home, then there's clearly likely to be an Article 8 impact in that context.
If it's discriminatory that you haven't had it, then you may well have a legitimate expectation that you should have it.
In any event, we're talking here about ambit. We're not talking about violation. In removing a benefit, one can quite see how that would be a violation absent any justification. But I can't at the moment understand how you say that it doesn't at least come within the ambit of Article 8, which surely it does affect your personal life, does it not?
Well, about whom are we speaking in this context? The children, rather than the survivor,
Well,
who may or may not be receiving some financial benefit as a result of this payment, bearing in mind that the payment is made to the survivor, It may be that the benefit cascades or not to the children, one cannot say, but it doesn't necessarily follow that the payment of widowed parents' allowance will inure to the benefit of the children. One can't assume that.
But if,
That would be true of so many things that are designed with the same purpose in mind.
Indeed, and that's why Article 8 is not engaged for those so many things. What we say, the proper test for the court to apply is to examine whether or not the simple provision of resource through a benefit is enough to engage Article 8. We say it must be more than that in order to engage Article 8. And that, we say, is underpinning the reasoning in some of the Strasbourg cases, maybe read into Carmichael, and can be read into some of the Court of Appeal authorities with which you will grapple in due course. In other words, we're saying if all that's in play is money or some more money by way of a benefit without more, that's not sufficient to fall within the ambit of Article 8. Because if, and the corollary of that is, if, on the other hand, the payment of benefit or some more income in a family scenario is enough to engage Article 8, then the entire sweep of social security benefits will be falling into the same category. Or any other measure or provision which advantages fiscally children in a family will engage the same requirements and justification. That, we say, is the logical outworking of the more expansive reading of the Article 8 ambit argument as articulated by my learned friends for the appellant.
you're using the engagement of Article 8 as synonymous with coming within the ambit, is that right? In other words, your submission is that if it doesn't engage Article 8, then by definition it can't come within the ambit of Article 8, is that right?
Well, no, I don't think I'm going to maintain that as my submission.
Sure.
I'm saying that in order to come within the ambit, in this context, in respect of a social security benefit, it must be something more than possible financial advantage to the children in order to engage, in order to come within the ambit. I'm not equating.
There's a terminological problem because I understood, I may be completely misguided, the two terms to be synonymous as Lord Kerr was suggesting. In other words, engage, something's engaged if it's within the ambit. It doesn't mean say it's infringed because that may only arise through Article 14.
Sorry, I'm suffering from the same terminological difficulty. Those two terms I am using synonymously, not infringing, engaging. So engaging and ambit are the same concept. My ladies, my lords, there is more jurisprudence on this point beyond Carmichael, and there are cases cited against me with which I must deal on this topic. There is a decision in the Court of Appeal in DA. You'll find that at volume 6 of the authorities, tab 64, 1167.
DA is the other benefit cap case.
Other benefit cap case,
Yes.
yes.
Well, that's coming to this court.
In 2 weeks' time, I think.
Oh, no.
Later?
Before the end of the summer term, I think. Same constitution as heard SG, for obvious reasons.
Yes. The Court of Appeal decision is at tab 64. And the key paragraphs are 94 to 96 of Lord Justice Elias' judgment. 3167 is the MS reference. '96 in particular, the Court of Appeal's view was that the granting welfare benefits can probably be described as a modality of the exercise of an Article 8 right in circumstance where at least one of the purpose of housing benefits to enable families to live together in appropriate accommodation. The question, therefore, is whether imposing a cap to limit those benefits has more than a tenuous connection with the core values protected by Article 8. Again, one sees there the feature of the benefit that is relevant is that it allows families to live together in appropriate accommodation. It's directed to a particular function of family life, how they are accommodated. So the benefit goes directly, there is a direct link to the modality of Article 8. We say in contradistinction to WPA, which does not have any such direct connection. That same paragraph cites Petrovich, and in passing I can touch on that since we're on the page. The appellant relies on Petrovich. Petrovich, of course, is a case where what was relevant was not just the parental leave benefit, but the fact of parental leave. So the person was denied parental leave and the relevant benefit, therefore could not discharge the relevant modalities of Article 8 in respect of family life. It's the same point. The question must be whether or not the benefit goes and is directly linked to a way and a means of discharging the Article 8 obligation. Smith and Bullock, or Smith Bullock, and Lancashire Teaching Hospital is also relied upon against us. You'll find that at volume 5. Tab 48, MS 2802. Mr. Donoghue spent some time on this decision, and the relevant passages are at paragraphs 55, that's page 2820. And you'll see how it's expressed by the Master of the Rules. If the state has brought into existence a positive measure, which, even though not required by Article 8, is a modality of the exercise of rights guaranteed by Article 8, the state will be in breach of Article 14 if the measure has more than a tenuous connection with the core values protected by Article 8 and is discriminatory and not justified. Not necessarily to find an adverse impact, although the complainant is not entitled to the benefit of the positive measure in question. And then at 72, you will see that reasoning is worked through. It's apparent from the very fact that bereavement damages are limited. This is MS 2822. It's apparent from the very fact bereavement damages are limited to the spouse or civil partner of the deceased that bereavement damages are specifically intended to reflect the grief that ordinarily flows from the intimacy which is usually an inherent part of the relationship between husband and wife and civil partners. Now, a number of points about this decision. It is not about a benefit. It is about creating a head of claim whenever there is a private law action in tort in respect of bereavement. So the state is paying nothing in this context. It is the tortfeasor who will meet the bereavement damages claim. So it is in a different category from the contribution-based welfare scheme that we're interested in.
You could say that that was a stronger case because the state's involvement is indirect.
Arguably so, really. But there are other features about this, I think, which are, it may well be a fact-specific analysis. This is a case where there was an internal inconsistency in the statutory scheme. Dependency benefits were payable. It was an obvious outlier not to make the same payments available to cohabitees for bereavement damages. So there was an inherent inconsistency in the statute. There's no question of these benefits, it's not paid for loss of dependency. It's not directed to children. And it is, as paragraph 72 observes, directed to compensation for the grief that flows from the intimacy between two partners. That's a world away, we say, from widowed parents' allowance. It is not directed to compensation for grief. It is, on our case, to make provision for loss of earnings, returning to the world of work, and dealing with matters of that nature. So we say Smith can be contrasted with the scenario we're dealing with here. We say this case is about potentially modest increase in funds going into a household. That's not sufficient to come within the ambit of Article 8. That is properly to be characterised as a A1P1 property interest. That is the correct prism through which to view this issue. And I should say, it's not in the papers, but the court may, in due course, look to the first instance judgment of Mr. Justice Ousley in the SC case, which grapples with exactly these issues. Judgment was issued on the 20th of March, I think.
What's the date again, please?
SC,
SC.
20th of April, I'm sorry.
That's too hot off the press to be in that number.
No, it would, no chance of getting into the electronic format, I'm sure, but we can't even get hard copy. But it's very recent and it's very on point, and in fact, the issues we're debating were in play there.
And the paragraph numbers? Just so that we can look them up for ourselves
Yes.
if we feel that way inclined.
Yes, the Article 8 issue is dealt with from paragraphs 94 through to 107.
Thank you.
Neutral citation is 2018 EWHC 864.
WHC
864.
8.
864 admin, yes. So, on the difficult case, if we are within the ambit of Article 8, contrary to what I've submitted to the court, the appellant still has difficulties in this context. Firstly, we say it would be necessary to consider the Article 14 status that is being relied upon. So we know about the cohabitees case. We know what the status is there. What about the Article 8 children's case? What status is being relied upon? And here there is a notable lack of precision on the part of our opponents. What we say the court must guard against is defining the status by reference to the alleged discriminatory treatment. Is the status here the fact that there are children who are denied access or whose surviving parent is denied access to WPA because of their cohabiting status? If that is the other status that is relied upon, it is defined by the operation of the legislation and by the allegedly discriminatory act. It is a classic bootstraps type argument. And it is not sufficient, we say, to ground an Article 14 type case. The appellant and indeed the intervener have not identified with the precision necessary for this court what the relevant status is that's relied upon in respect of the Article 8 children's case. But it appears in our submission, on any analysis, to be the type of status that is of the peripheral and debatable kind, to use the language Lord Walker used. And if it's in that category, then that goes to the question of justification. What is behind the argument that Article 8, the ambit of Article 8 is in play in this context, is the introduction of various international instruments as a guide to interpretation, or indeed a legal obligation upon the state. And here we have again traversed territory which this court has already addressed in other contexts. Reliance is placed by the appellant on the decision of the court in ZH Tanzania and Bioku Betts. ZH Tanzania is in the supplementary bundle, I'm afraid, hard copy, will have to be used. 7B. Tab 78, MS 3510. court will be familiar with what ZH Tanzania was about and the factual circumstances of it. I won't go through all of the detail. But the passage that's relied upon is in the judgment of my Lord Kerr at paragraph 46. There's reference being made here to the international instruments that are in play and the importance of the best interests of the child. And the last sentence of that paragraph is relied upon. What is to be determined in a child's best interest should customarily dictate the outcome of cases such as the present. Therefore, it will require consideration of substantial moment to permit a different result. Now, that is relied upon in the context of arguments about UNCRC to advance the case that actually on analysis what needs to happen in this type of case is it needs to be shown that the measure contained in the statute is in the child's best interests. But we say that's to read too much into my Lord Kerr's statement in paragraph 46 because it is qualified in itself because it refers to cases such as the present, which is a case involving the disruption of a family unit by an intrusive act of removal. Indeed, that's an observation that my Lord Hodge makes in the Zumbas case, which has also been relied upon against us. But you will find that in the same volume 7B at 3530. Paragraph 12, which is in 3535, where my Lord Hodge notes that paragraph 12. It's important to note Lord Kerr's formulation spoke of dictating the outcome of cases such as the present, and that in ZH Tanzania the court was dealing with children who were British citizens, and goes into the detail of that. So, obviously, Lord Kerr will have his view about this. We say the appellant and the intervener overstate the import of ZH Tanzania, and we say there is a distinction to be drawn between the type of scenario we're dealing with, where we have, in the hard case, a loss of £10 per week from a benefit, with cases like ZH Tanzania, where a family unit is being disrupted perhaps forever by a state act of deportation.
Lord Kerr was on the panel in Zumbas, so he didn't disagree with what was said in paragraph 12.
I can't remember the case, but I visited that particular paragraph in ZH in a later case, but I can't remember the name of it at the moment.
I'm sure if it helps you, my Lord will remember in due course, but if it's against me, you...
Well, I think possibly it might be in your favour, but I can't remember.
Yes.
Just going back, as a matter of interest, SC, which does look interesting, Mr. Justice Ooze's decision is on Bailey.
Yes.
So it's difficult to digest, but it may be, I don't know how far you say it's a direct analogy, but it deals with child tax credit and withdrawal.
It's deals with universal credit, and I have no doubt it's a case that may well go further. But
he certainly, I mean, he comes to the conclusion it doesn't engage.
Yes.
Article 8.
It doesn't engage Article 8.
And he examines most of the authorities we've been looking at.
Exactly, yes. And he comes to the conclusion again that even with Carmichael, even if Article 8's in play, the open question is how far does that take you? And what is the boundary line? The boundary line I've suggested to the court is the boundary line he adopts in that judgment. So one is looking for cases where there's been a removal of a benefit and there's been some direct link with the Article 8 modalities. We say that's a proper principle which this court can endorse in this appeal.
In the last 10 days we haven't had copies of it.
Sorry, no.
No, I mean, we can get them.
We can furnish them. So we say, again, the court will be cautious in its treatment of the argument based on UNCRC and the other international instruments put forward by the appellant, of which there are a number in the papers. Because we say that the Child Poverty Action Group are inviting the court to go beyond the boundaries of the jurisprudence of the European Court of Human Rights in this context. And again, in a similar vein, my Lord Hodge, in the Muhan case, which is in the bundle, Volume 2, Tab 17, MS 1653, rejected an attempt to use the ICCPR for the same purpose in a decision about prisoner voting, and was of the view that decisions based on Article 5 ICCPR do not assist the court in its interpretation of the provision by the European Court. So we say that even if we're within the ambit of Article 8, and even if the appellant can establish a status with the appropriate precision, then it still does not necessarily follow that the international instruments relied upon should be applied in this context to an extent that goes beyond anything the European Court has itself done in cases of this type. Bearing in mind, of course, the general proposition that the European Court recognises that social welfare benefit provision of the type we're dealing with falls within the wide margin of appreciation afforded to states. The argument that's being advanced by the appellant and the interveners would lead the court into making policy-laden judgments in the area of welfare benefits. And we say the court should guard against that. Some assertions have been made about the, particularly by Mr. Donoghue, about society's position and evidence in respect of marriage and cohabitation. This case may well not turn on such matters, but just to redress the balance, there is some material which the court might wish to look to in respect of research on cohabitation and marriage. It's been put in evidence by the NCB, the intervener in this case. Can I show the court on this point Core Volume 2 at 951. It's a House of Commons research paper on the extent of cohabitation and marriage. And what you will see in the graphical presentations on that page is not a fundamental sea change as between marriage and cohabitation, but a gradual trend of cohabitation increasing. There is in Core Volume 1 at MS 376 a useful research paper. This is the one produced by the NCB, dealing with the development of cohabitation. You'll find that at 376 and following. Within that paper, which I won't take the court through, you will see an acknowledgement by those who are essentially aligned against us here that cohabitation is an increasing feature of society, but it is also often a step on the road to marriage, and that is often part of an increasingly long prelude to marriage. You will see, interestingly, at page 382 of that research paper, a discussion in the paragraph at the bottom of the page about the awareness which cohabiting parties have of the financial benefits that attach to marriage. More than 2/5 of cohabitants, it says in the second last line, are aware that marriage gives couples more financial security, yet have still apparently chosen to cohabit. So the fact that there are positive fiscal and social security benefits attaching to marriage is not unknown. As I've said, there are many benefits to marriage,
Well, 2/5 is less than half,
well, there's an awareness, lady.
so there's an awareness by some. Was this paper written before or after the big book by these same authors?
I think it's before.
I think it's before
Yes.
too. I think we've got more up-to-date
Yes.
information.
As I
There's
say, I
also
don't-
a very wonderful study of engaged couples. You can imagine nothing more enjoyable than researching people who are happy,
well,
which is very rare for social scientists. But that revealed that they had very limited notions about the difference between being married and living together, and that they were not getting married because of the fiscal and other advantages, as a general proposition.
well, again, when examining this case,
Wishy-washy.
we would note that this case and the legality of this provision will not turn on the facts of Mr. McLaughlin's situation. We will look at this case, and the court will look at it systemically and structurally. So while there are undoubtedly hard cases at the margins, and this may even be one, the approach that's required is to look at the scheme as a whole rather than at the individual circumstances of a particular case. And when we speak of the scheme as a whole, I invite the court to look at the scheme in the context of the general social security provision that's available to survivors and children. It is not solely about widowed parents' allowance. There may well be other state benefits that meet the international norms which are relied upon by those who are opposed to me in this case. My lords and ladies, I think I've probably covered the ground that I want to cover rather briskly, more briskly than I thought. If the court has any questions for me, I'm happy to address them, but those are our submissions.
It would appear not, but thank you very much indeed. Very economical, if we may say so. Yes, indeed. Mr. Lanning, beautiful.
Just very briefly, Melody, I don't really have very much to say, but if I could ask you to, in the first instance, go to Core Volume 2. You've asked about the history of the benefit, and Dr. McLean has been good enough to refer you to the paper in relation to the benefit for the 21st century. Could I ask the court to go to page 848? I think page 850 was opened by my friend, and 851 as well, in terms of what was out of scope. You'll recollect 850 was...
Well, we're not going to draw an awful lot of attention to the fact that the government decided not to consult on something.
No, I'm not. No.
It's not. I
No,
don't think
I've
much reliance has been placed on that.
I've worn that argument out many years ago.
I should have said, in fact, to Mr. McLean, I think we would find the House of Commons research paper on the history of the development of this benefit, that one. I've been looking at it and it looks very helpful in setting out the basics. So if you would be kind enough to supply, yes. Thank you very much. Yes,
Yes, my lady. Well, simply to draw the court's attention to page 848, a document, at the top of the page it's got the heading, The Complexity of Bereavement Benefits. It then deals with the complex payment structure, bereavement payment, bereavement allowance, and then it deals in the centre of the page with widowed parents' allowance. And you will see that I don't know if function means purpose or intention, but it describes it as a function, and it says providing support towards the additional costs of raising children. It's not a payment linked with children. Its function is not to promote marriage. It provides support. and that's a very clear articulation, we say, of what anyone standing back from this legislation, stripped of the explanation offered by the department as to the purpose of this legislation, which is that it is to promote marriage. But in fact, it shows what we always suspect it to be, which is a recognition of the need to provide support to the surviving parent towards the additional costs of raising children. And exactly what you have said, my lady, in relation to the tripartite dimension historically of the benefits that have been paid to widows. One never likes to be sabotaged in the Supreme Court, but the reference to SC, I have to confess, I had not been aware of the judgment. It came out last week, and it's a first instance judgment, and it was only, my attention had not been alerted to the content of the judgment. It just arises in the context of the dimension of this debate vis-à-vis what the Court of Appeal has said in DA, and the short number of authorities. I haven't had a chance to read that authority at all. I wonder if we might be permitted to supply you with a short additional submission, no more than a couple of pages, dealing with this first instance judgment and how it may fit into our submissions.
It's extremely unlikely that it'll stay where it is.
It
may stay
it is indeed
changed, but
yes.
I don't think it'll stay where it is.
Yes, Millie. I think that the parties are really joined in relation to the issue of ambit. Obviously, yes. I have relied upon a seam of authority which says that it doesn't take very much to get within the ambit of Article 8, even within the context of social welfare benefits, and that is my primary submission. But I'm a little hesitant about trying, as it were, on the hoof to respond to a first instance judgment that I haven't read and see how it factors in, for example, in relation to DA and those other authorities. And I wonder if we might be permitted just to simply add in no more than 2 or 3 pages.
No more than 2 or 3 pages
yes,
within the next week,
within
please.
the next week, certainly,
yes.
my lady.
And if, of course, Mr McLean thinks he's got anything to add to what he's already said, he may do so.
We'll circulate it, my lady, and get it in. But I feel that I just need to go through it in a little bit more detail than perhaps I can do on my feet. In fact, the judgment came out after Miss Mountfield's submissions were presented, I think, at the back end of the week before last. So it really is a very recent decision in its first instance, and I just haven't read it. My attention hadn't been drawn to it. I apologise for that. Unless there's anything further, my lord, those are our respectful submissions.
Just ask you about the continuing payment of the benefit.
Yes.
Do we have the details of how, of the conditions for the continuing payment of the benefit? Let's suppose a situation in subsection 3C.
Yes, my lady.
Where the relationship is the residing together. I mean, just suppose, it doesn't matter if it's that one, any situation in which the survivor ceases to live with the child.
Circumstances change.
Yes.
Yes.
What happens then?
My understanding was that the benefit would cease, but
it probably matters to know.
yes, it does. Yes, my lady. You've asked a factual question. I'm just trying to deal with a factual answer. My understanding, my lady, was that the benefit ceased at that time. That the surviving partner no longer qualified.
Well, the pregnancy one is obviously going to develop rather than cease. There must be some regulations or conditions somewhere.
The answer in short form is not that I've read.
Okay.
Perhaps we can do some further research just in relation to the pregnancy point that's been raised by Dr. McLean, and also in relation to the 3C point.
It doesn't even have to be that one. It could be your own child who you're looking after, and you lose custody.
You lose the child.
Yeah.
Yes, absolutely. Or the child dies.
Yes, that would be another.
Or something,
yes.
some untoward event happens. My understanding was that the benefit ceased at that stage. I hesitate to give you an answer which is not predicated upon a document or fully researched, and again, perhaps, sorry, my lady, I'm just been, it does, yes.
Well, it would be really helpful,
yes,
I'm sure, to all of us,
yes,
if we had a simple, clear account
I note.
of, given that the conditions of entitlement do arise at the death,
yes,
how long the benefit goes on for.
Yes,
and I feel fairly sure that this can be agreed between the parties,
yes.
and you can let us have that.
Yes, my lady, but as I understand Lady Black's point, it is, what are the, do all actions cause the benefit to cease in the event that there's an untoward event or a...
The thinking behind it was just to see how close an association it was between the presence of the child with the survivor,
Yes,
and the payment of the benefit.
yes, my lady, yes, I understand the point that you make. Thank you very much, my lady.
Well, thank you all very much indeed. It's good to have had such an interesting and difficult case to be our first in this fine city. We shall now go away and work out what we think the answer may be. We should, of course, make it clear, should we not, that what you're seeking is a declaration of incompatibility. You're seeking a declaration of incompatibility. It's not, therefore, going to do any immediate good to anyone, because even if such a declaration were to be made, which is a big if, of course, it doesn't oblige the government to do anything at all.
No, my lady. It's a historic case in that respect, yes, ma'am.
Well, as I say, thank you all very much indeed. Court will now adjourn.